So to start off, I think it's very important for parties to understand that the best interest of the child principle always applies with regard to children's matters. Many people are under the impression that if you have, money or you have certain type of authority, that you are entitled to have custody over your child. That is not necessarily the case. Having a bit of money could maybe prove to the court that you are able to care for the child. But if at the end of the day it comes about that you cannot care for the child because you're at work all the time, you're busy, you have no skills to care for a child, under those circumstances, the court may make an order that you pay child support to the other parent, and the other parent would be, mandated to care for the child. We receive many questions on our blog regarding aspects of, child custody, how to win a child custody case, what problems you will experience in a child custody matter. So I'll start with the basic question. Number one, can a father obtain custody of a child if the child was born out of wedlock? This is a very important question, firstly, because not all fathers automatically have parental rights and responsibilities over children. For instance, if a parent was married to the father, if the mother was married to a father, automatically the father will have parental rights and responsibilities over the child of care and guardianship, etc. What that basically means is that he will have a say and authority over the child. But for argument's sake, let's say a father was not married to the mother, he made the mother pregnant, and the child was born, and he disappears and he comes back into the picture 5 years later. Under those circumstances, because he was not married to the mother, the court will not automatically grant him parental rights and responsibilities over the child, meaning he will basically not have a say over the child's life. But at the same time, if a father was not married to the child, not married to the mother, and he is involved in the child's life from the birth of the child, he paid child maintenance, he had contact over the child, etc., then the law says he automatically acquires parental rights and responsibilities over the child. Meaning, under those circumstances, he can have a say regarding the child's schooling, education, contact, guardianship rights, etc. The challenge a father would have who never had any initial rights of parental rights and responsibilities over the child, he will have to prove that to the court. So he will have to come to court and say, yes, correct, I was the mother, I am the father of the child. However, I unfortunately could not partake in the child's life when the child was born, but now I am willing to do so. I have tried to do so, but the mother has now refused me from doing that. If he can prove there was some type of effort made on his side and is willing to partake in the child's life, the court will now look at the situation as it is, and the court will obviously now try to phase in some type of contact in allowing ultimate parental rights and responsibilities to be applied to the child where the parent is concerned. So those are the questions usually unwed fathers will usually ask. But the question we also get that gets posed a lot to us is where the mother and father, for example, they were married to each other, now they're separated. Now a whole custody battle comes about. For argument's sake, the mother, she believes she can better care for the child, and the father also believes that he can better care for the child. This becomes problematic here because we might have a situation where both parents can care for the child. Under those circumstances, it's very important for the court to have the assistance of experts. This is where social workers come in, child psychologists, maybe the office of the family advocate. The problem the court has is the court only has in front of him or her, paperwork. He never meets the parties involved. And how can you make a decision as to who will be the better caregiver for the child? You can't do that because he never meets the child. Sometimes he never meets the parents. He never sees the parents in court because, in example, high court applications regarding custody, the parents do not have to appear in court. So under those circumstances, the court will obviously obtain the assistance of a child care expert, the family advocate's office, and be guided by those experts. but the court will not necessarily, does not necessarily have to follow the expert's recommendation. You'll have to listen to both sides of the story, and then based upon that, you can make a decision. But if a client comes to my office and he says, "Sir, I have been involved in my child's life since the child's birth. I was in a relationship with the mother. He might have been married to the mother. But the problem I have now is I don't think the mother can properly care for the child." So we have a situation here whereby the child was cared for by the mother primarily since the child's birth. And now we have now we have the father coming to the table and saying, "I would like to have this whole situation reversed, whereby he now wants to be the child's primary caregiver." This becomes very difficult to determine, because who says he can care for the child? That's the first question I have to ask him. Why does he say he can care for the child if on paper and historically the mother was the one that cared for the child all the time? So he'll have to convince me, he'll have to tell me and explain to me, number one, firstly, that, maybe when the child was born, he was always there, he changed the nappies, he fed the child, he took the child to hospital, he took the child for the, inoculations, etc. If he can say, "Okay, I have done that in the past," the question still is, can he do it in the future? And we shouldn't also disregard the capability of the mother being able to continue doing that. So from a legal point of view, he'll have to prove that it's best for the child for the status quo to change. For the child to now reside with him, where he now becomes the child's primary caregiver. The challenges we always have with those type of matters are, we tell the client, we can draft your paperwork for you. We can put your best foot forward. We can explain to the court everything. But unless you can convince the court that the mother is not capable of caring for the child, and secondly, you are able to care for the child better than what the mother can care for the child, we don't think your application will be successful. Then the father might come and say, "But I can pay more. I can pay for school fees. I can, give the child a better bedroom. I can give the child, a pony," whatever the case may be. That the court will not necessarily consider. The court may consider a situation like that if the mother does not have any place for the child to stay. But as I said earlier on, under those circumstances, the court may make an order, or the court might direct the mother, "Please go to the maintenance court." And the maintenance court can now order the father to pay adequate maintenance, because he says he can afford it, so that the child can live with the mother, and the mother can get proper accommodation for the child, because the court is convinced that the mother can best care for the child. Then we get the situation in child custody difficulty matters regarding third parties. What are the rights of third parties? And the question that was posed here, the rights of grandparents regarding child custody matters. So when I deal with third parties, I don't only deal with grandparents, I deal with step parents, maybe, for example, a couple that was in a relationship. He doesn't necessarily marry the mother, but he wants to be involved in the child's life. What can he or she do? The same principle applies. The child's best interest is of paramount importance. Now, the difficulty in this situation would be a grandparent, a boyfriend, a step-parent does not have any parental rights and responsibilities over a minor child. Those parental rights and responsibilities are only obtained by two individuals, a mother and a father. However, the court can assign those specific parental rights and responsibilities in terms of the Children's Act. So if a third party now wants to come in and say, "No, I feel that I need to have certain type of parental rights and responsibilities over my child. The grandchild always used to stay by my home. Every day I used to take the child to school, bring the child home, dress him or her, feed him or her, take him back to the mother's house and put the child to bed." That I've done for the last 10 years. Now, all of a sudden, the parents have separated, and now the grandparents are now being refused to have any type of contact with the specific minor child. Under those circumstances, it would make logical sense for the grandparents to apply to court and ask the court to assign them certain parental rights and responsibilities. Under these circumstances, it might be seeing the child every second weekend, or maybe continue collecting the child in the morning and dropping the child back in the evening. The same regarding step-parents. If the mother and father, the mother and the stepfather got into the picture, they divorce. Now the stepfather wants to see the child. It's not his child, it's not his biological child, but he would like to continue being in that child's life. under those circumstances, clearly the law allows that if you can prove that it will be in the child's best interest for the specific stepfather or those no longer married to the mother to have contact rights or any type of other parental rights and responsibilities, the court will order that specific, make that specific order if it's in the child's best interest. Now, many clients will ask me, what strategy can you apply? You now are either you're the parent of the child, the other parent has primary care over the child. What do you have to do? Now, we all know in terms of the Children's Act, not too recent, but 10 years ago, it says that if parents are experiencing difficulties regarding contact and care in relation to their minor children, what should they do? It says, first thing you do is, Section 33 of the Children's Act, you have to try to enter into a parenting plan. So a parenting plan is basically an agreement between the mother and the father where they outline certain things, for example, visitation, contact and care, maintenance, etc. If at the same time, after having tried to enter into this parenting plan with an expert, could be a social worker, psychologist, family advocate's office, another suitably qualified person like an attorney or a mediator, only then, if it is determined that you cannot resolve this issue regarding contact and care, then the Children's Act says, then you may approach the court. But when that specific provision came out about 10 years ago, many legal practitioners, in my experience, they implemented that specific provision. But it seemed to me that over the years, people started disregarding that. They never made use of Section 33 in trying to enter into a parenting plan. So, but this is a strategy going forward. If the parties can agree on a parenting plan, then that specific parenting plan will outline all the issues the parties have and try to find solutions to it. So the mediator or the person that facilitates that specific parenting plan, he will look at the father's life, the mother's life, look where the child is, and what is a workable plan in order to parent the child or the children going forward. If they can come to such an agreement, wonderful. That specific agreement or parenting plan gets registered at the Office of the Family Advocate, or it can be made an order of court. The question is, what's better? I would say having it made an order of court, because then you have a court order as opposed to have something that's just registered at the Family Advocate's office. And even if you look at the regulations in relation to the lockdown, at the start of the lockdown, it only allowed parents to collect children or for them to move from their home to the other parent's home to collect the child and return the child later if there was a court order and, of course, a parenting plan registered at the Office of the Family Advocate. And then also you have the parental rights and responsibilities agreements where third parties, they acquire certain type of rights, for example, a grandmother or a step parent. So that's the first step to apply, to try to enter into a parenting plan. So you'll see a lawyer, you'll see an attorney, the attorney will draft a parenting plan, send it to the other side will peruse it, they might come with a counter parenting plan, or they might agree to go to a professional to assist the parties. Should that process fail, obviously that's where you want to go forward, because difficulties now has arose. Then the best thing to do firstly would be to decide now which court to approach. If you cannot necessarily afford legal representation, lawyers are, it costs money, then you have the option of going to the Children's Court. The Children's Court, in my view, is more of a quasi-judicial criminal operation, whereby there are clerks involved, they assist you, etc. Whereby the High Court is more you on your own. You have to do everything yourself, and nobody will necessarily assist you in the process. So if fees are an issue, then I would still advise you go to the Children's Court. However, if fees isn't necessarily an issue, then obviously you can approach the High Court and have a legal representative draft your paperwork for you and process it for you, etc. Whatever the process you follow, number one, you need to outline to the court firstly, why do you think or why do you believe that you are entitled to have contact rights to your child? Because being the parent of the child does not necessarily mean that you are automatically entitled to dictate what type of contact you want to have for the child. you still need to prove to the court that it's in the child's best interest. So you have to look at the situation. You have to look, okay, the child lives in this specific suburb. I live a bit further away. You know, daily contact will not work. So I need to unpack it. So if I feel that, you know, every second weekend will work, wonderful. I need to unpack. Why do I say every second weekend will work? You have to consider various aspects, the child's schooling, the child's extramural activities, and also the age of the child, of course. If, for example, I believe that co-parenting will work, I separated from the mother, the father and the mother, they lived together for the last 10 years. The child is now 9 years old. They separated and they live 5-minute drive away from each other. Under those circumstances, if the fact supports it, for argument's sake, the father works a 9-to-5 job and the mother does the same. Under those circumstances, the father can convince the court that co-parenting should continue, in the sense of they were co-parenting the child while they were living together, and now, you know, they have separated, but they can obviously still care for the child, whereby the child will see both the parents at an equal amount of time. So how will that generally work? With my experience, I think 1 week on and 1 week off, that might be too much for the child. So the best situation might be, for argument's sake, where the child maybe lives with a mother or the father, for example, maybe from the Sunday evening until the Wednesday evening or till the Thursday morning, and then they swap from the Thursday morning or Wednesday evening until the Sunday evening, and the following week they swap again. So you have a situation where both parents see the child at an equal amount of time during the week, and at the end of the day it will be an equal amount of time during the year. But if you cannot prove to the court, if you come to the court, and this is a problem which I see other lawyers do, you know, maybe less seasoned lawyers, where they draft paperwork and I peruse this documentation because a client comes to me and he wants to oppose it. They either say, I am the father, I'm entitled to see the child, the mother is refusing me contact, and therefore I would like to have this long list of wishes. You know, he wants to have the child for this day and that day. And so unless he can convince the court why he's entitled to that, the possibility of him or her winning the case will be very, very slim, because it doesn't give the court much to work with. And the court will obviously be limited to what the experts have to say. So if you believe a certain type of contact is workable and applicable to your situation, you need to unpack it very well in the documentation. So you start off from the Monday. You start off on the Monday saying, I should pick the child up from the mother's house on a Monday morning with the child's clothing and whatever schoolwork the child might have, and I will drop the child back at the mother's house the Tuesday morning. And the reason for that is because I attend to the child extramural activities on a Monday, and it won't make logical sense for me to drop the child back again. And the child is used to staying at my house because the child has always been living in my house for the last many years, and we are accustomed to that. So that is how you will get over that hurdle. The other parent, whoever it is, might decide no, he or she opposes that specific suggestion. Then he or she will have to say why it will not work. But unless you unpack it fully from top to bottom, from the Monday morning until the Sunday evening, and obviously you're dealing with school holidays as well, unless you unpack it completely in a very well outlined and detailed affidavit, the possibility of you being successful with that is very limited. Many parents, you know, they deal with the custody battle with us. So we draft the court paperwork, the other lawyer on the other side, he or she drafts the paperwork, we argue it, we get some type of interim relief. Then the court refers the matter now obviously to the Office of the Family Advocate, who appoints a social worker, and they have interviews with the parties. The challenge you will have is, number one, firstly, you might be nervous, you might not be used to being interviewed by these professional people. But the challenge you will have is, unless you have a document behind you to back up exactly why you're saying you want to have care and contact, why you say you want to have shared care, why you say you want primary care, and that document obviously is the court paperwork that you submitted to the High Court, or if it's a children's court, your affidavit. Unless you have that and it's well outlined, you'll have an additional burden at the Family Advocate's office, for argument's sake, to now explain to them, whereby you had an opportunity previously to do it in the documentation. So I caution many practitioners, number one, and also litigants litigating on themselves, In child custody matters, always imagine yourself, what would you tell the court should you be sitting on the witness stand? So if this matter was a trial, what will you tell the court? Will you start with saying, I would like to see my child, and because I'm the father of the child, or because I'm the mother of the child? Or will you outline to the court why you believe the child should be in your care for a certain amount of time? Obviously, you'll do that if you have to be the witness stand. The same when it comes to your legal documentation. Take it from a point of view, judges, it's very fast, and if I do not put any information in the specific documentation, I cannot do it later on. And if you think you can do it later on in the office of the family advocate, he or she might just hear what you have to say. It doesn't mean he or she will actually record it and take note of it. So that's the one aspect. Another question which we as legal practitioners often come, to our offices are, the mother or the father is refusing the contact. Now that's obviously, not in the child's best interest for a child not to see a parent regularly. So what generally happens is mother and father, they fall in love, they have a child together, they live together for 2 or 3 years, they separate for whatever reason, mother lives with her parents, or she she rents a flat or whatever she does, and now she refuses the father contact. Now, the strategic answer under those circumstances to any father, if that happens to him, I would say the longer you leave the situation as it is, the weaker your case ultimately becomes. And that's a reality. If the child is 3 years old and last time you saw the child was a week ago because you lived with a mother and you guys separated, it's very easy for the court to say, no, child goes back, child should now be shared between the parents because that was what the child was used to. If the father, or whatever other parent it is for that case, approaches the court 6 months later and he says, 6 months ago I lived with a mother and now we separated and I never saw my child for 6 months, although the mother could have been at fault because of that. Maybe she's not, maybe she was, but although she was the one that limited the father's contact or refused him contact, the court will still have to consider the fact that he never saw the child for 6 months. Now the question is, do we phase in contact? Do we all of a sudden give the father 50-50 rights? What do we do? That is where the problem comes in, because now the court will have to look at the situation from a different point of view. If the child is now 2 years old and the child never saw the father for 6 months, has she forgotten about the father? Does she or he see the father as a stranger? Whatever the case may be. So it's very important that the moment there is a difficulty, a problem regarding child contact rights, to immediately see a lawyer, go to the social worker, or go to the court as soon as possible. The longer you leave things, the worse it is for you. There's many times where we've been successful representing fathers in child custody matters, whereby the child was cared for by the father for extremely long time, and now the mother comes from nowhere and say, hey, in terms of the divorce order, I'm supposed to have custody over the child. Yes, she has in terms of the divorce order, but the court will not look at a divorce order in isolation. The court will have to re-look the matter and say, okay, ma'am, you might have custody over the minor child in terms of the divorce order, but the reality is you did not have actual contact with the child for the last 2 years. We cannot just enforce that divorce order. We have to re-look the matter from the start again, and now we have to decide what is best for the child. So the reason why I'm using the scenario for the mother and that the mother is a primary caregiver, it just makes it much more easier for the listener to understand the concept. But there are many cases, and I've dealt with many of them, whereby the father himself has been granted primary care custody over the child, where the mother had to have supervised contact or limited contact to the minor child. It all depends on the facts of the case. So a question which was posed to us was, what percentage of fathers win child custody matters? Obviously, it's impossible to say. The same way, it's impossible to say what percentage of mothers win child custody matters, because each case is different. It all depends upon the parents' reasonableness, where some parents will accept the fact that they cannot see the child, or they should not see the child during certain periods of time, or they should be limited in seeing the child because of the circumstances, where other parents will accept that, and other parents will say, no, I'm fighting this other parent. I'm fighting him or her for the sole reason because I believe that he or she needs to be taught a lesson, or it's an ego issue. We don't advise anybody to take that specific route. I believe that you must take a reasonable approach to the matter, and the more reasonable you are, the more the possibility of the court seeing that you will get what you're actually entitled to. We are running out of time, so I will just conclude on a few points. The first point on this issue of child custody difficulties, always remember the court looks at what's best for the child. If you proceed on that basis in what's best for the child, you will get a much, much better result than proceeding on the basis that because I am the mother or I am the father. That doesn't necessarily work. I've dealt with custody matters whereby that was the attitude, I'm the mother, I'm the father, but then the court gives custody to the grandmother or to the uncle or to someone else, because that was the attitude. Your attitude would be, yes, I am the father, but I believe it's best for the child to be my primary care or for me to have contact because X, Y, and Z. If that's a reason and a rationale behind that, the court will look at that and the court will be more favorable to your case.